Hello, thank you for joining us today for our webinar as we cover 10 things to consider as you're planning your estate and you're doing your estate planning and your will. We hope that you'll find this helpful in demystifying the process as far as we go through this. My name is Chris Fahey, and I'm a gift officer here at the University of St. Thomas. In my role, I work with families who want to make an impact at St. Thomas through their philanthropy. Joining me today in the studio is Ben Carpenter. Ben, welcome.
Thank you, Chris. Ben Carpenter. I've been doing estate planning law for about 15 years. I've started out for a number of years at a large firm and more recently started my own practice. And I'm also a senior fellow at the St. Thomas School of Law. So I'm thrilled to be here today. Look forward to our conversation and to answering as many questions from the audience as we can.
All right. Thanks, Ben. During the next hour, Ben and I will be covering information to help you demystify the estate planning process. We also hope it will provide you with some helpful tips as you consider creating or updating your own estate plan. During the webinar, please send in your questions. We've set aside time at the end for Q&A. So let's get into them. Here are the top 10 considerations that we will be covering today. Number one, what is included in estate planning? Number two, we're going to cover when should you be thinking about your estate plan. Number three, what if you die without a will? And number four, what are key issues to address in your will? And number five, what is the difference between a will and a revocable trust? And I'm going to let Ben cover the next section here.
Thank you, Chris. We'll also talk about the things that you can't do in a will. What are some common mistakes that people make when they do their estate planning? We'll cover generally what the key tax issues are that you should be aware of and discuss with your attorney. We'll also wrap up with how much of this you can do on your own and how much it will cost to work with an attorney to put this all in place.
All right, great. Okay, let's jump in then to our first item on the list then, Ben. So item number one here, we're going to cover to help take some of the mystery out of what estate planning is. Can you talk about what is included in estate planning?
Yeah. Absolutely. So when you do your estate planning, when you meet with an attorney for the first time, what they will be thinking about, whether you have $1,000 or $1 million or more, a basic estate plan package includes a will or a revocable trust. And we'll talk later about the differences between the two and when it might be appropriate, a healthcare directive, and a power of attorney. Those are the three main documents. But in addition to that, you want to make sure that you cover with your attorney other assets that aren't covered by the will. And so assets that are covered by your will, we call probate assets because they go through the probate process to get distributed.
Yeah.
Other assets, though, aren't governed by your will, such as those that have title, real estate that you may own jointly with another person. When you die, it goes automatically for the title to the joint owner. And then a big one is assets that have a beneficiary designation attached to it. And those primarily would be life insurance proceeds upon death and retirement accounts, a 401k, IRA, 503b, a pension. When you open that account or when you purchase that policy, you're really entering into a contract with the custodian. And part of that contract is that they are agreeing to distribute the assets according to the beneficiary designation you complete. Right. So you really want to make sure that those beneficiary designations are coordinated with the plan in your will. Otherwise, you could have a great will that says one thing, but if the designations don't coordinate, it's not going to accomplish what you think it's going to accomplish.
You had mentioned a healthcare directive as well as a power of attorney. Right. Can you just explain for our audience what those two items are?
Yeah, absolutely. So a financial power of attorney is a document you sign that allows somebody else to be an agent for you for financial purposes. Okay. So they could, if you're not able to for any reason, take a step that you need to, they could go to a bank or whatever it may be and do that on your behalf. And that's often done for people as they age, and maybe it's more difficult for them to do it, or they don't have the capacity to do it. But it can also be for younger people if they're traveling and they get stuck in another country or somewhere and something needs to be done. For instance, my wife and I were traveling at the time that we refinanced our mortgage, and the closing for that happened to be while we were gone. So my father was able to sign the documents on our behalf with the financial power of attorney.
Great.
A healthcare directive, on the other hand, similarly, you appoint somebody else to make decisions for you, but in this case, it's with respect to your healthcare. And unlike the financial power of attorney, this only becomes effective if you're not able to communicate your wishes yourself. So as long as you can, a physician is going to ask you, what do you want for your care? But if you're not able to do that, then the physician will look to your healthcare directive and to the agent that you've appointed and ask them what you want for the care. So it's really important to have that in place. And then the second piece of a healthcare directive is referred to often as the living will piece of it, where not only do you name somebody to make the decisions, but you specify in the document what your wishes would be for those decisions. And that's very important because, if you name somebody but haven't had that conversation about, if it's an end of life issue, what your thoughts are, you're putting them in a very difficult spot to have to make that call for you. And it's always going to be a difficult spot, right? No matter what. But certainly, at least there can be some comfort in looking at the document and seeing, well, this is what, my mom or dad has said they want, and I'm going to carry through their wishes. Takes
that guesswork out of it.
Exactly.
So you've covered on some of the basics. Are there some more complex items that might be covered as well?
Certainly, estate planning can be much broader than that. Those are the three items that apply to everybody. But if you have a significant wealth, you may have estate tax issues, and so there's some estate planning that can go on there. With irrevocable trusts and so forth. If you have a cabin, that's a unique property. If you want to pass it to your family, there's some ways you may want to go about doing that, and either through a trust or an LLC or similar entity. If you want to do charitable planning, if you want to do prenuptial agreements and that type of stuff, that's all covered on the umbrella of estate planning, but a little more complex than certainly we're going to cover today.
All right. Well, thank you. Well, we're going to move on to number 2. So, Ben, when should someone think about creating their estate plan?
Right. There's a couple of trigger points in people's lives where they really start thinking about estate planning. The first is obviously the birth of a child. The first child. That's when people start to think about it. In my experience, that's often not when people first do it, but they at least start having the conversation. They may not get around to it till that second or third child, or maybe they're taking their first trip as a couple without the children, and they want to have something in place. But that's a time when you want to be thinking about it. And, a lot of young people feel that maybe even then they don't need to because they haven't accumulated much wealth yet. But one really important piece there is to get a guardian in place for your minor children if something were to happen to both of you. You want to have some say in who's going to raise them after that. And you can do that through a will. The other thing is, people often are a little wealthier than they feel because some of their wealth may be in life insurance. So while you'll never get the benefit of, by definition, during your lifetime, if you were to pass away, your children would receive the benefit of that. And even if you never purchased life insurance, you may have it through your employer. And so that's a good time to do it. A trigger point. Another one is when people become empty nesters. Maybe they did it when they were younger, but that was 20 years ago. Situations changed. And they want to look at it, review it, update it, or they never got around to it, and they have accumulated some wealth now, and it's a good time to put that in place. The third situation is certainly as people age, as they get older, it becomes more real, more of a current issue for them, and they get more serious about putting something in place if they haven't done it yet. But certainly any time along the way from that spectrum as well, if you have a significant life event, often it may be a parent passed away and you inherited some money. That's also a kind of a triggering event where people really think about getting that in order and meeting with an attorney to do this.
So once someone has an estate plan in place, how often would you recommend, or should someone update it or think about updating it?
Well, the nice thing with the estate plan, if you put one in place and it's done well, it should be a really flexible document that can kind of self-adjust for changes that'll happen during your life. So if you have additional children, the document itself should have language that'll take that into account. If you were to lose a child, it would have language that would take that into account. If the tax laws change, if your assets change within at least a certain spectrum, the document will be able to reflect that. So ideally, you will do it, and you may not need to revise it for 10, 20 years, maybe even longer. But that said, I certainly recommend that people pull it out off the shelf and look at it every year or two at least to make sure nothing significant has changed in their wishes. And it may not be the assets, but it may be the people that they've named in the will to do some of these things. Whether it's guardian for their children or to be the executor of the estate. It could be just simply that's one of those people have moved to a different part of the country. It doesn't make sense anymore, or some other change in relationship.
Great. All right. Well, that will bring us to item number 3 on our list. We've heard a lot about Prince's estate. As far as the fact that he didn't have a will when he passed away. What happens if you don't have a will when you die? Can you talk about that?
Yeah, absolutely. So, we joke in the estate planning community, everybody actually has a will. You have a will, I have a will. Most people don't realize it, but they do. The problem is the legislature drafted it for them, and we say if you like everything else they've done for you, you should be set. But if you don't have a will, that's called dying intestate. And intestate statutes then have a provision or a scheme for what happens to your assets. And generally speaking, if you die without a will and you're married and you have children all of your children and your spouse's children are from your relationship, everything will simply go to your spouse, which is what most people would want.
Right.
If you have children from a different relationship, though, your spouse will get a certain amount. It's about $200,000. And then half of everything else will be split between your spouse and your children.
Right.
If you don't have a spouse or children, it'll go up to your parents and so on. And there's a whole chart that explains that. The problem with those statutes, I mean, it's a great default system.
Mm-hmm.
The problem is it's kind of drafted to say what the most common scenario would be if someone didn't have a will. But of course, none of us are that person.
One size fits all.
One size fits all. We all have our own unique situations and relationships and so forth. So if you want to do anything other than that, there's just no mechanism in the statute to accomplish that. So for instance, if you want to give assets to a niece or a nephew or a friend or something like that, you can't do it. If you want to make charitable gifts to, church, school, St. Thomas, for instance, there's just no mechanism for that. And it doesn't matter if you've told everybody in the world or all of your friends, I'm going to give this amount to this person. If it's not in a will, the court's never going to let it happen under the statutes. And then likewise, if you have minor children and you want to maybe put assets in a trust for them, we can talk about that later. There's just no mechanism for that. So whatever they receive, they're going to get, you're going to have to appoint a guardian, a custodian, or a conservator.
Sure.
And when they turn 18, they're going to get the assets, whether they're ready or not for it. So.
Oh, great. I'm glad we covered that. So as we go on to our next consideration, number 4, what key issues should be addressed in your will? Can you talk a little bit about that?
Yeah, when I talk to clients, I like to think about the will in 2 components. One is the people involved, and then after that, the property involved or your assets. With the people, what I'm really talking about there are kind of 3 groups. One is if you have minor children, who should be the guardian of those children, right? Yeah. It's a very important consideration. 2, who should be your executor? In Minnesota, the term executor, we use personal representative. But it's the same thing.
Good to know.
Most people are more familiar with executor.
Right.
Who do you want to be the person to administer your estate, to collect all the assets, pay your final taxes, pay your final debts, if any, and then make sure that what you've said in the will gets carried out? Okay. And then 3rd, if you do name a trust for your children or grandchildren or anyone else, who's going to be the trustee of those trusts? So basically the person who then takes the baton from your executor and then manages the assets going forward until the trust ends. So that's the people, the main categories of people involved. And then the property is, where you want your assets to go. And there I really think about it in terms of who you want it to go to and how you want it to get to them. Okay. So property.
Maybe timing or.
And timing, exactly. So property, it could be, do you have personal property, collectible, jewelry, gun collection, coin collection, something like that you want to designate? Do you have specific amounts you want to give to a person or an institution? That's typically called a specific gift in a will. And then after that, how do you want everything else to be divided? And that's called the residue. And that's typically divided into shares, like evenly amongst my children or half here and half there or so forth. So that's where it should go. But then how it should go to that person or entity is important too. Do you want it to go to them outright, or do you want to have some restrictions on how they receive that? So if you're making a charitable gift, a restriction could be, do you want to make an outright gift to the school?
Right.
Or do you want to have some restrictions around what the school can do with it? And in that case, you would certainly work with an officer like yourself to craft that. You want to make sure that you cover that in the will as well. When you're giving assets to people, sometimes you may not want them to receive it outright. The classic example, if you have minor children.
Sure.
They're not going to be ready for it. Or even adult children, oftentimes, depending on your estate, they may not, you may not be comfortable with them receiving it if you were to die. So in that case, you'd want to do some sort of trust for the benefit for the recipient until it's the right point in time for them to receive the assets.
Well, great. Well, you brought up trusts, and we've talked about it a little bit. Can you do a quick overview about what a trust is?
Yeah, great. And that's an area that a lot of people, they know the term, but they may not really understand what it is. Simplistically, one way to think of a trust is really nothing different than a different bank account. Okay. But with that bank account, there's restrictions applied to it. And there's 3 main parties to a trust. Okay. One is the settlor, also sometimes called the donor or the grantor or the truster. But that's the person who creates the trust or puts assets into the trust. Okay. 2 is the trustee. So that's the person then who has the legal duty to manage those assets, to make distributions or not make distributions for as long as the term of the trust exists.
Sure.
And then 3rd, you have the beneficiary, who's the person or persons who are entitled to receive assets from that trust, whether it's along the way or at the end. And a trust can be as the terms of a trust you control. They can be as creative as you want them to be. There are some tax limitations that an attorney can walk through with you.
Okay.
But generally speaking, you can make a trust as flexible as you want. And it's a great tool because of that.
So we've talked a little bit about trust, and we also talked about children. Can you talk about the trust for kids?
Right.
They seem to be the most common, and what are some considerations or key considerations within that?
Yeah, they're definitely the most common in a will. And when I say trust too, I should clarify, it's not, the trust terms can be in the will itself.
Okay.
You don't need to create a trust today. That would be there in case you were to pass away. You can do that, but more common, the terms are just embedded in the will itself. And if the conditions exist that you set forth at your death, then the trust will come into being. Your executor will create the trust, put assets into it, and the trustee will manage it. So for instance, if you say, if my children are under age 30, I want it to go into a trust. If they're under age 30, the executor will create the trust. If they're not, it'll just never come into being. And generally speaking, the duration of the trust is a key. How long do you want it to exist? Until they're 25, until they're 30, for their lifetime. Sometimes that's appropriate, particularly if a child with some special needs. A lifetime trust may be a really...
We have some families that have special needs children, and we've heard about special needs trusts being put in place.
Yes, absolutely. So that's a great use of a trust, and that often is typically a lifetime trust. And it kind of depends on your own situation, your kid's situation, your assets. But, usually age 30 to 35 or so is kind of a standard approach. And then the other piece of it is how much discretion you want to give the trustee with distributions. Common distributions would be if they're getting married, you can make a distribution for assistance with that, for college or education, if they're starting a new business. But you can give the trustee the ability to receive a request and decide if it's appropriate or not. Or you can you can require certain distributions. You can require distributions along the way. Again, it's kind of as creative as you want to be. But an attorney can tell you what is standard, what's typical, and give you some ideas around that as well.
And so we've talked about trust for kids, but we also have talked about guardians. So if a child is a minor, should a trustee and a guardian be one and the same?
Yeah, that's a great question, and there's no right answer to that. A lot of people want the guardian and the child to be the guardian and the trustee to be the same. Just it's efficient. If this is the person who is going to be raising your child, if you were to pass away, it may make a lot of sense that they have control of the assets as well. On the other hand, some people really like to separate those two functions and have one family in control of the raising them and the other one in control of the finances. And that depends on a lot of family dynamics and other things. So there's no right or wrong, but if people in the audience are wondering, it can certainly be done either way. There's no right or wrong there.
So our last question I have within our number 4 consideration. So we talked about trustee. Is there a cost or fee involved with having a trustee?
Right. So with a guardian, there's not. A guardian generally will just act. A trustee, it depends. A trustee is always entitled by statute to take a reasonable compensation. And they're going to be taking on some risks. They're going to have responsibilities, investments. They've got duties. So it's appropriate for them to do so. Generally speaking, if you name an individual trustee, maybe a family member, an aunt and uncle of the child, usually in my experience, they won't take a fee. They'd be entitled to, but they don't. By definition, you've passed away and they're doing this kind of as a favor to you, and they don't take a fee. You could also appoint a corporate trustee or an independent trustee who maybe doesn't have a family relationship. And sometimes that's appropriate to do. I always say, if there's some dynamics that may make it difficult for the trustee to receive distribution requests and deny them. If you have a corporate trustee, they're not going to be sitting across the Thanksgiving table after they've said no. So that's going to be appropriate. And they certainly will take a fee to do that as they should. And usually that fee is right around about 1% of the asset value, of the trust value each year.
So that brings us to our item number 5. When it comes to estate planning, we hear a lot about wills and revocable trusts. Can you talk a little bit about how a will and a revocable trust are used differently in the estate planning process? Yeah,
absolutely. So, that's a great point, Chris. What I've been talking about in the last couple minutes is really irrevocable trusts. So trust can be revocable or irrevocable. By their definition or by their terms, an irrevocable trust, once you create it, you can't change the terms. So if it's in your will and you pass away, once you've passed away, that's how the trust is going to be administered.
So
and
it's locked.
It's locked in. And that's great because
Right.
that if that were to happen, that's what's going to happen. That's what's going to be. There's some ability to change it if you go through the court system sometimes. But generally speaking, that's the rule. A revocable trust, by its name, can be revoked. It can be amended. It can be changed at any time. And a revocable trust is really used as a will substitute.
Okay.
So if somebody primarily if they want to avoid that probate process, if they die and they don't want to go through the court system and incur that cost and some of the requirements, they can create a revocable trust where the trust is in existence today. Okay. They'll be often their own trustee. They're the only beneficiary. They can change it any time. So it's kind of just like another bank account, but it is considered technically its own entity so that when you pass away down the road, the trust continues on. And you will appoint a co-trustee or a successor trustee. Mm-hmm. He or she or it, if it's an entity, will come in at that point and take over for you and distribute the assets as you have specified in that point. At that point, the revocable trust becomes irrevocable, and they wrap it up.
So it's there's a conversion point on that.
Exactly.
Okay.
Exactly.
So we've talked about what a revocable trust can do. Mm-hmm. So what can't a revocable trust do?
Yeah. Well, a couple things. This is a common misconception is people often will come in and say, I want to do a revocable trust because I want to avoid estate taxes.
Okay.
Revocable trust, there are some things within it you can do, but it's no different than a will from that standpoint. Because it's revocable, because you can retain complete control, the IRS ignores the trust for estate tax purposes and for income tax purposes. Okay. So if you want to do some tax planning during your lifetime, an irrevocable trust is usually the vehicle that people use for that, or one vehicle they use for that.
And we have families that have done that at St. Thomas.
Certainly, yeah. The other thing that it can't do is avoid creditors. It doesn't provide any creditor protection, again, because you really retain complete control. If you have a creditor, a judgment against you, they can usually attach those trust assets just as they could your individual assets. So those are the two things that they can't do. So why would people use a revocable trust versus a will if they can't do those? Well, one is to avoid the probate process. Okay. In some states, it is a very costly. In Minnesota, it's not that bad of a process, but a lot of people want to avoid it anyways. So that's one reason. And in particular, if a client owns assets or real estate in multiple states, they own.
So maybe down in Florida or Arizona.
Exactly. Or the two most common, right? Yeah, they live here. They have a vacation home in Florida or Arizona. If they were to pass away, they would have to go through the probate process in Minnesota. Okay. Then they'd have to hire a Florida attorney and go through the probate process in Florida to transfer title to the Florida home. And that does get costly and so forth. So to avoid that, a revocable trust, you can create it, put the title to both properties in the revocable trust. And again, because it's technically its own entity, when you die, your successor trustee, the trust continues on, and the successor trustee then will just distribute the assets under the trust terms without going through the probate process. So that's one big reason. Another reason people like revocable trusts is if there's any privacy concerns. Mm-hmm. You mentioned Prince did not have a will. If he had done estate planning, he almost certainly wouldn't have done it through a will. He would have done it through a revocable trust. Okay. A will goes through the corporate process and becomes a public record. So if anybody wanted to look at your will, I think for most of us, that's not a concern, but for some of us, it certainly might be. If you're a celebrity, or even if you just have, significant assets, or maybe even just you're doing something strange in the will and you don't want it to be out there in the public domain, a revocable trust will avoid that. So those are two big benefits. And then the final benefit to a revocable trust is we mentioned at the beginning, powers of attorney, which will allow somebody to manage your assets for you if you're not able to. Well, a revocable trust is effectively the same thing, but just much more robust. You put all your assets in it. If you lose capacity as you age or for any reason, your successor trustee who you've nominated or you've appointed, or your co-trustee, can just simply take over for you, and they have access to everything right there. And so you don't need to rely on the powers of attorney. They can do what they need to with that.
So how do you go about setting one up as far as a revocable trust? Right.
That's a key point. And that's what some people disincentivizes some people to do it. Yeah. If you create it, a key part is in funding the revocable trust. Because if you can have it on paper, but if you haven't taken the steps to actually fund the trust, you're still going to have to go through that probate process. Okay. And what that means is for your investment accounts, retitling or opening a new investment account in the name of the trust, and then transferring the assets from your existing account into that. Bank accounts often are the same way. But certain assets you can't do. Retirement accounts, you can't do that. So again, you want to coordinate that with your estate planning attorney and make sure that you're funding it to the extent you can, and then having the appropriate designations for the other assets.
Great. Well, that wraps up our number 5 consideration. As we move into our number 6, we've talked about how a will can be used in the estate planning process. Can you touch on what can't you do in a will?
Right. Yeah. So there are certain limitations. The big one is you can't completely disinherit your family. Right.
Okay.
You can to some extent if you want to, but if you're married, in particular, your spouse and your minor children are going to have some statutory rights that you can't take away from them in a will or in a revocable trust.
Yeah.
And generally speaking, what that looks like, there's exempt property. There's a couple categories. There's exempt property, which includes your home.
Mm-hmm.
You can't give your home to somebody else.
Okay.
Your spouse at least will have the right to receive the home.
Okay.
And again, if you don't have children, he or she will receive it outright. If you do have children, he or she will get at least a life estate in it, with the remainder to your children, meaning your spouse can live there for the rest of her life or his life. And then when he or she dies, the children will automatically receive the title to the property.
Right.
Also, your spouse is entitled to about up to $15,000 of personal property of yours that they can choose, and 1 automobile. So if you have 3 cars, they can choose which one. It doesn't matter, cost. They can pick one of those as well. So that's the exempt property. They're also entitled to an allowance or your minor children of up to $2,400 a month for 18 months to kind of help them through again, this is assuming you've otherwise didn't include them in your estate plan.
Okay.
And then the big one, though, is what we call the elective share. That's a statutory right where, depending on the length of your marriage, your spouse has the right to a certain portion of your estate.
Okay.
And they call it the elective share because they don't have to take it, but they can elect against your will to take that if you provide it otherwise.
Okay.
And what percentage depends on the length of your marriage. It starts at about 3 or 4% if you've been married for a year. It increases each year up to 50% after 15 years, and then it stays at that point.
Okay.
So, and the calculation actually includes your assets and your spouse's assets, and it's 50% of that. But there's nothing you can do in a will to prevent your spouse from having that right.
So there are some circumstances, I would say, some families may want to do that.
Sure.
How would you go about doing that if you wanted to not have that be the case?
Right. Absolutely. Yeah. So the only way to avoid those statutory rights would be through a prenuptial agreement.
Okay.
Or a postnuptial agreement after the wedding. But if you think it's a difficult or awkward conversation before the wedding, try it after you're married, right?
Right.
So typically it's done before the marriage through a premarital agreement. And premarital agreements, they kind of have a bad reputation a little bit. You always, in the media, when you hear about them, it's because something went wrong, usually. Okay. But there's a real place for them in estate planning for certain families. In particular, the most common is if one spouse is coming to the marriage with a lot more wealth, either what they've earned or often they received it from their family.
Sure.
Or if they have a blended family, maybe, you really want to make sure that your wealth goes to your kids, or at least have some control. So a prenuptial agreement simply allows you and your spouse to collaboratively agree before the marriage. What's your interest? What are your concerns? And let's agree to a framework that's going to satisfy those, rather than, again, leaving it to a judge to determine, or all these other things that can be costly, and you don't have control over the outcome all the time. So, and the other thing I always want to make clear with prenuptial agreements is they're simply establishing the floor for what you're required to do and for what your spouse can rely on. You're always entitled to do more than that for your spouse. And in fact, most people do. Ideally, you do a prenuptial agreement. You never pull it out again, and you live a full life together, and you give everything to your spouse upon death.
Okay.
But if anything happens, and it's not just a divorce, it could be an early death, that you at least have a framework that you can be sure about.
Great. Well, that wraps up our number 6 consideration. Number 7, wanted to ask you about, you've been in practice as an estate planner for many years. What are the most common mistakes that you've seen in your practice as far as when families come in and either are doing the planning or have done planning and bring the plan to you? Right.
It's usually not on the planning side. It's usually the following through afterwards.
Okay.
The biggest one is, as I mentioned, not coordinating your probate assets and your non-probate assets. So you have this will, then you have your life insurance, your retirement accounts, and really with many people these days, the majority of their wealth is in either life insurance and their retirement accounts if they were to pass away, and their real estate.
Okay.
You take that away, there may not be a lot left. So you could have, a will that says, I want everything to go to my children in trust until they're age 30, but you could have the majority of your assets held over here, and the designation just says it goes to my kids.
Right.
And that's it. So they may get very small trusts and very large amounts here, which is not at all what you wanted.
Right.
So that's probably the most common mistake. Or updating, maybe that you had it all in place at one time, but now you've opened a new IRA or rolled a 401k over, and when in that process you don't do the correct beneficiary designation.
Okay.
That's one to keep in mind. Another one, we talked about funding revocable trusts.
Right.
It's important that you fund it. Now, if you fail to do it, it's not the end of the world. The results aren't as bad as the first example. But if your purpose of creating a revocable trust was simply to avoid probate, you haven't accomplished that if you don't fully fund it and get the assets in there. And so I should clarify too, if you meet with an attorney and you're talking about a revocable trust, you will still do a will as well. But we call it a pour over will. It's usually 2 or 3 pages. And it simply says, if I haven't fully funded my trust, if there's any assets outside of the trust at my death, then distribute it to the trustee to be distributed according to everything else under that.
Okay.
So it just kind of pours into that. But to do that, it needs to go through a probate process in the first place.
And is there a threshold as far as a dollar amount that it would cover up to? Or
yes, in Minnesota, at least as of now, it's set, if you have $75,000 or less, you can typically still accomplish that through an affidavit without going through the probate process. But if you have anything over $75,000 and collectively everything put together, then you're going to need to file with the probate court and go through that process.
All right. All right. Well, that wraps up number 7, I think, unless there was anything else as far as mistakes that you wanted to cover that we hadn't already covered.
One other one is the probate avoidance. That's a very popular concept.
Yeah.
And it became really popular in the 80s. There are a lot of books written about it and how to do it and so forth. And it's a valid thing, but there's other ways of doing it as well. For instance, life estates. If you take your real estate and you give your children or you keep a life estate and give your children the remainder, or you put them as joint owners on an account title or a real estate, those accomplish the same thing, but they have definite risks involved, and it doesn't always accomplish what you wanted it to. So what I would recommend, the more effective way of doing that, avoiding probate, would always be the revocable trust, which you can change at any time. The life estate, you're giving them a legal interest. And if you do that and 10 years later, change your mind, there's no taking it back. Or if you want to sell the property, they need to be signatories on the deed and so forth. Hopefully they'll cooperate, but it's a little bit out of your control. Or with a joint title, if you name your, say, 3 children, one of them passed away and then you pass away, the other 2 will get the full account. There's no mechanism for the deceased child's share to go down to your grandchildren. With a revocable trust, you know that'll happen.
Well, good. Well, that gets us through number 7 as far as our considerations. Of course, when we talk about estate planning, as we go into number 8 consideration, always will come up where people are thinking about key tax issues that are related to estate planning. And I was wondering if you could just touch on the different issues that you would typically encounter during estate planning. Yeah,
that should be a part of every conversation that you have with your attorney. And there are 4 main taxes that apply to this process. Income taxes, estate taxes, gift taxes, and the generation skipping transfer tax. That 4th one, I'm just going to get rid of right now. That, generally speaking, we only really start thinking about that under today's law, at least, when couples have 30 million or more of assets. So if you're in that ballpark, talk to a lawyer for sure. But the income tax, there's a couple issues there that come up every time. One very common question I get is, if I receive assets from my parents, if I inherit assets, is that income to me? Do I have to report that to the IRS? And the answer is every answer is generally speaking, right? Generally speaking, no. There's a specific provision in the income tax code that exempts inheritance or gifts. So if you get a gift, if you get inheritance, you don't report that as income. But the other issue that you should be aware of is basis. And by basis, we mean if you purchase an asset, the cost that you put into it, what you paid for it, becomes the basis. Right? And so if you bought a stock for $10 20 years ago, and it's now worth $30 and you sell it, the difference between what you sold it for and your basis is the gain. And you report that as a capital gain tax.
So that's where that comes in.
That's where that comes in. And the difficulty with that for many people is if they've got highly appreciated assets,
Right.
they're kind of stuck with it. They may want to sell it, they may want to diversify it, but they can't do that without incurring a large capital gain tax. So one approach would be to do some lifetime charitable planning. That's a great asset to give away to a charity because they can receive it and then they can sell it without incurring any income tax because they're tax exempt or very little at least. So that's a great asset if you're charitably inclined to keep in mind. It can help reduce your estate. You can avoid that income tax hit as well. But for these purposes, what you want to keep in mind is under the current law, when somebody dies, the basis in all of their assets, again, with some exceptions, steps up to the value of the asset at the date of their death.
Okay.
So that $10, that $30 stock that they bought for $10, that they held it till they die, and it goes to you, your basis in it becomes the 30.
Oh.
So if you turn around and sell it, you don't report any gain tax. Or very little depending on the value when you sold it. The same applies to property and so forth as well. So those are the basis is a big piece to keep in mind. And that was one of the taxes or the items that was on the table for getting rid of that basis step up with the last tax.
For the federal reform,
Exactly. They didn't do away with that. But whether they do 4 years from now or 10 years from now, it's unclear. But as of today, that's the law as well. Now, we should point out there are certain assets that are not included in that, and the biggest one would be retirement accounts. Okay, and that's most retirement accounts.
For the last couple of decades, that's become a very huge asset that families are now owning.
Yes. Yeah, and again, for many people, it's the majority of their assets. So, and the reason for that is because the whole point of it is you put assets into the account, you get your you get a deduction on your income taxes, and then it grows tax free until you pull it out.
Okay.
The IRS wants to get it at some point. So if you transfer that at your death to a beneficiary, they don't pay any income tax when they get the account. Okay. But anytime they pull assets out, they're going to be taxed on those, just like you would have been if you had done it before you passed away.
And here at St. Thomas, we work with families that if they were to gift those retirement assets to us upon their passing, we are a nonprofit and would be able to help with that bypassing of those capital gains and then provide a life income if needed to that family.
Absolutely.
And then create a charitable deduction as well with that. So
so when we're talking about lifetime giving, we always look for appreciated assets because of that income tax issue. If we're looking for assets to do at death, a retirement account or any other similar type of account is that ideal asset to choose because you can avoid the charity at least can avoid all that income tax that's accumulated. And again, you can do that through a beneficiary designation, not necessarily through the will.
Okay. Yeah. And then, so we've talked about income tax. Now, how about the estate and gift tax? We've heard a lot about that of late with our federal tax reform.
Right. So those are the final two to be aware of. Let's start with the federal issue. So everybody has an exemption amount. Okay. And what we mean by that is that's how much you can give away that's exempt from tax before the tax kicks in. Okay. And so under the new law as of 3 weeks ago, the exemption per individual from federal estate tax is 11 million. Okay. So if you have under 11, there's nothing to worry about. In addition, each individial has that.
So that's for a
married couple. Exactly. So for a married couple, it's basically 22 million.
Okay. Wow.
And if you give everything to your spouse, you don't use up any of that. You get a marital deduction. And your spouse effectively inherits your exemption as well. It's called portability, if you've heard that term in the news. So your spouse's exemption becomes 22 million. Okay. It's a great thing. How does the gift tax play into that? That's an exemption that applies for any gifts that you make over a certain amount at least during your lifetime or at death. Okay. You can give up to $15,000 away during your life without it counting against that exemption, or anything you give to a charity doesn't count against it. Anything you give to your spouse, or if you pay for your children's medical expenses or education expenses, that doesn't count towards that exemption, against the exemption. Again, with some exceptions, so make sure you're following those if you do it. But the point is, if you do make a $1 million gift during your life to anyone else, that's going to reduce your remaining exemption from 11 million down to 10 million. So when you die, your exemption would be 10 million. Okay. So again, very generous. When I started practicing, it was only a $1.5 million. Right.
That's changed a lot.
It used to be a 60% tax. It's up to 22, and it's now a 40% tax. So it just doesn't touch as many people as it used to. Okay. And probably something most of us don't need to even really consider at all.
How about here in the state of Minnesota?
Right. So that's a different story.
Okay.
So Minnesota has its own estate tax as well. It's one of, I think, 13 states now left that have it. Most states don't, but we do. And it's got a much lower exemption. It's a $2.4 million exemption.
Okay.
It's scheduled to increase up to $3 million in a few years, and then not scheduled to increase any further after that. So, and if you're beyond the 2.4, it's a 13 to 16% tax, a little graduated rate. And the difference, the one other difference though, is there's no portability aspect as there is in the federal estate. So if you die without doing any tax planning in your will or rev trust, and you give all your assets to your spouse, she doesn't get your $2.4 million exemption. So actually we put together a little slide to help illustrate this concept. This is called a credit trust planning. It's one of the more basic trust planning techniques that your lawyer may discuss with you to avoid the estate tax. But let's look at this example right here. Hypothetical couple, assume a husband has about 2.4 million in assets. You can guess why I came up with that number. The exemption is 2.4.
Nice number, yes.
But assume the husband has 2.4 million of assets. The wife has 2 million of her own assets in her own name, and together they own a home worth $400,000. Okay. Joint tenants. At the husband's death, generally speaking, most people give all the assets directly to the spouse. And so if he dies first, the wife receives his 2.4, and now her total estate would be 4.8. Okay. So if she were to pass away, that exemption applies, but it's only 2.4. So anything over the 2.4 is going to be subject to Minnesota estate tax at that 13% roughly rate. And it's about a $300,000 estate tax.
Wow.
Anything else, anything left then can go to your kids or whomever else you've designated. They get about 4.5 million. Okay, so it's cost you about $300,000. Now, you can avoid that though with some very simple planning in your will, what we call a credit trust. And the concept is, rather than giving those assets directly to your wife, and this could be from the wife to the husband, they're usually drafted reciprocally. Instead, you would say, I'm going to give all the assets to a trust. We call a credit trust. And the term credit is because in the tax code, that exemption amount that I referred to as a credit. Put the assets into a credit trust. And then when my wife dies, those assets aren't considered a part of her taxable estate. Okay. And actually, she can be, the trust can be very flexible. She can be her own trustee. Mm-hmm. She can get all the income from the trust. She can have some limited withdrawal rights as well. And as long as it's done within the specific parameters, it'll be outside of her estate. Then when she dies, you can see she's got the $2.4 million exemption. Her assets are only 2.4, so she's got no estate tax. The kids get the full amount, and you've saved about $300,000 in taxes. And that obviously, as your assets grow, that savings increases as well. So that's a very standard approach that if you're anywhere over 2.5, 3 million, your attorney should be discussing with you at least and seeing if you're interested in that.
Well, as you mentioned earlier too, you don't think about it, but you had life insurance and maybe your home as well as your retirement assets. You could get there and you may not realize it.
That's absolutely right. And the life insurance is the key one. Almost always when I ask someone what their assets are, they leave that out because they, again, by definition, you never get the benefit of it until you pass away. Then your survivors do. But the IRS is going to include that in your taxable estate for state tax purposes. And so you want to coordinate that. And maybe that's the asset that you put into the credit trust.
Well, on the credit trust, you had talked about as far as setting this credit trust up. Does someone have to then, once you set it up, actually carry that out, or how flexible is that?
Right. That's a great question. I mean, all things being equal, most people would prefer not to have, they'd prefer to receive it outright, not have a trust, right? Yeah. So what you can do with this, it's a really nice technique. The slide I showed assumed it would be created. Okay. You can actually put the provisions in the will, but make it contingent, and make it contingent upon your spouse's election to create it or not. Okay, and that's called a disclaimer. Mm-hmm. So we call that a disclaimer credit trust. Okay. And what would happen is within 9 months after you die, your will would say everything is going to go to my spouse. But if she or he disclaims her interest in the will, then those assets are instead going to go to this credit trust. Okay. So this is already in your will. Then your spouse, when you die, can sit down with their advisors, look at your assets, look at the tax laws at the time, and decide, do I really need this trust or not? Will it be beneficial? And if he or she decides it will, she can disclaim the assets and they'll be created. If they decide they don't want this, maybe they've moved to a different state without an estate tax. It makes no sense at all anymore.
Right.
They simply don't file a disclaimer, and it all goes to them. So it's really great. It's just a really great kind of a fail-safe provision you can have in there, and you're not committed to it at this point, but it's there if you need it.
Great. Well, that wraps up our tax section, and then want to move on to our number 9 consideration. So as someone goes to prepare their estate plan, Ben, how much of this work can they do on their own? And we've talked a lot about maybe some very simple things and complicated, more complex.
Right.
What can someone do on their own?
Like anything else in life, you can do it all on your own if you want to. You can wire your own house.
Sure.
You can you can be your own realtor.
Yeah.
But there's some real value, obviously, to working with a professional who does this all the time. And also, like everything else, the issues aren't those that you're aware of. They're the things that you don't know, about it. And for instance, real estate or retirement assets.
Yeah.
If you want to, coordinating those beneficiary designations is really important. But if you simply say, I'm going to put it into a trust for my kids, you need to have very specific provisions in that trust so that you get the income tax benefits that you're trying to get. If you don't, then it's going to accelerate the income. So I always just say you can do it on your own, but work with an attorney if you can, and somebody who specializes in this, not necessarily someone who does it, as a little small part of their practice, because these laws are changing all the time. There's always unique issues. I mean, everybody comes in and says, I've got a really simple situation, and it rarely is that simple. And I, like we talked about at the beginning, it should be something that if it's done right, it can be flexible, it can be self-adjusting. You do it one time and it might be good for 20 years. So it's worth making sure, and just for the peace of mind, making sure it's done right. And people, they spend your entire career accumulating wealth, and so working so hard for it. Why not just take that extra step and make sure it's going to be passed on appropriately to your kids as well?
So that brings us up to our number 10 consideration. So we've talked about a lot of planning, and what are the range of costs on this? Can you talk about that?
Right. I'm sure that's on everyone's mind too. So, just simplistically, you can break it down into two main groups of people. You can go to a large firm or you can go to a small firm, more of a boutique firm. Again, I'd say one that specializes in this. And there are definitely places for both of them. With a large firm, you're going to pay a little bit more or a fair amount more. But some people, and I say particularly if you have other legal issues, it might be really helpful to go to a large firm, because they can address this and they can coordinate it with other aspects of your legal issues. There's someone down the hall they can pull in if they need to. So if your business has environmental issues or something like that, that may make a lot of sense. But if that's not the case, or if your issues are more of a family law or an elder law situation, most big firms won't touch those things. Then you can probably get everything you need from a smaller firm, and again, one that specializes in this. So there's a place for both. Generally speaking, cost, I think if you go to a small firm, boutique firm, it's going to be roughly $2,000 to $3,000 for the package we talked about. If you do a revocable trust, it may be a little more, there's a little real estate work and stuff as well. If you go to a big firm, roughly speaking, you can double it, usually $4,000 to $5,000 or so to have it all done correctly.
But if there's some more complex issues, they would probably
if there's more complex issues. One other difference that people sometimes really like, smaller firms are often more willing to do flat fee work, where they'll give you a quote, they'll look at your assets, look at your situation, give you a quote up front, and that's what it is. And it's really nice because you're certainly welcome at any time to call with questions, and you're not getting billed for that. Larger firms just typically aren't as willing to do that. They'll give you a quote, and it's a quote, and then they'll charge you what the actual time is, and that may be fine for you as well. But that's something to just keep in mind.
All right. Well, we've covered our 10 considerations today, and as we now we're going to pivot over to our question and answer period. And we've had some questions come in. We did get some in advance. So someone had asked about what estate planning considerations might you want to think about as far as for a family cabin. We had brought up the cabin a little earlier, and
it's a common one in Minnesota. A lot of people have cabins. And one thing I just like to start with on that is they are difficult assets to determine what to do with. There's no silver bullet. There's no right way to do it. common ways that people will, well, the downside of not doing anything, you give it to your kids, now they each own a third interest.
Right.
They've got to agree on everything, and that can be difficult. One may live in California and never use it. The other lives here, and it's difficult. And then particularly if one of them, as they pass away, it's going to get further and further, diffused or fractured the ownership, making it even more difficult to manage. So a solution to that is to either put it into a trust or some other sort of entity like an LLC or a family partnership, where you can designate the trustee or you can designate the president of the LLC to manage the assets. Mm-hmm. Each person can get interests in the entity, and they can sell their interest to each other. They can give their interest to their kids, but you can have at least a common structure for it and so forth. Now, if you're going to do that, it's very advisable to also put some capital into that entity or the trust to at least for 5-6 years pay the expenses, so they're not having to chip in. That's one way to do it, but each of those have their drawbacks as well. And so it's a great conversation to have, but just be prepared you're going to have to make a tough decision ultimately on which way is best and for whatever reason. And often it may just be having a real honest conversation with your kids.
Right. Do
you really want this? Do you really think you'll use it?
And if
10
not,
years down the road, and if not,
maybe as far as a charitable consideration, if that's something.
Yeah, absolutely.
Okay.
Absolutely.
Well, great. Well, that was a question on our cabin. We've got a couple others that have come in here too. So is there a recommended, this is kind of goes back to the personal representative and guardian question. Is there a recommended practice on whether one's personal representative, executor, and trustee be or not be one and the same person?
So the trustee, again, the key thing is to find somebody for each of those roles, whether it's the same person or a different person who's well suited for that role. Okay. They don't need to be a financial expert. They don't need to be great at investing. You can hire somebody to do that. There's plenty of wonderful advisors in the city who can manage your assets for you. But you do need to be organized. You need to be detail oriented, keep good records, be able to address situations, family dynamic situations that may come up from time to time. And, with the guardian in particular, you're looking at who's going to raise my kids, who's going to follow the values that I have and pass those on to the kids. And are they local? Depending on the age of your kids, if they're junior high, you may not want them to go live with your aunt and uncle in Indiana, no matter how great they may be. If they're younger, maybe you'd be more willing to that. So that's a big, location is often the big issue for couples. And I should say guardian selection is often the one issue that keeps younger couples from creating a will. They talk about it. The assets they're comfortable with, they can figure that out. But, I want my brother to be it. You want your brother to be it, or your dad and mom and dad. And that's a difficult conversation. And so what I advise is, I understand it's difficult, but if something were to happen to both of you, something's going to happen to your kids, and you're going to have no say in it. Exactly. So then you're leaving it up to a judge to decide. And then you really could have a difficult situation where your two families will be arguing about it. Right. At least this gives you the opportunity to have the say in it, and avoid some real there may be some disappointment from someone else, but it's your kids, and you want to have the say in where they go. With respect to the executor, likewise, or the person representative, typically somebody local is better. They do need to be involved in the process. They need to be here to sign things. You can do it by mail, some of it, but usually it's ideal to have it. A trustee, I think you have much more flexibility about location. They can manage it from anywhere. Again, you're looking for that connection, that relationship. Do they understand what I would have wanted for my kids? Did they really understand my kids' needs? And so forth. And then one other point I should make of that, we talked about a corporate trustee versus an individual trustee. There are some outstanding people in town who are professional fiduciaries who will do this, be a trustee for you. It's kind of a nice between a larger institution who do a great job too sometimes, but can really maybe get to know the beneficiaries at a little bit different level and still provide those services as well. And you can do both. You could have a professional trustee who will do the investing and the tax and maybe make some of the tough discretionary decisions, and a co-trustee who's a family member who can advise them about the family values and so forth. And that's often a really nice solution.
That's a great idea. We have a question that's come in about what's involved in the probate process. So maybe on a big level, not in all the minutiae, but what does that look like? Right.
Well, and so we talked a lot about a revocable trust. And one of the main reasons is to avoid probate. Why do we want to avoid probate? As I mentioned, in Minnesota, it's a fairly slick process. It's not that bad, but you've got to go through the court. It's going to be a public record. the person's role is to collect all the assets. They get appointed. They give notice to creditors. Then you have to wait. Well, you don't have to wait, but creditors have 4 months to file a claim. You publish notice, publisher, and a legal newspaper for a few weeks. And then if there's a creditor out there that you're not aware of, they have 4 months to file a claim against the estate. The great part about that is if they don't do so, then they do it 5 months later, it doesn't matter. Their claim is barred. So that's a benefit of the probate process, but it also creates some delay, some additional costs. There's a filing fee, publication fee. Those will usually add up to about $500 to go through that, but you can avoid all that with the revocable trust.
So timing considerations, a little bit of cost.
Yeah. But whether you go that or the probate route or the rev trust route, a lot of the functions are going to be the same. Either person, they still need to collect all your assets. They still need to pay your final debts. They still need to pay your final income taxes. The estate itself becomes its own entity for as long as it's open, and any income that the assets generate during that period, they have to file a fiduciary income tax for if it's over $600. So a lot, you can't avoid all of those things with the rev trust, but you can simplify it. But sometimes then you lose out on that creditor protection. If that's an issue, I have had clients who will still go ahead and do both just so that they can cut that risk off down the road.
Great. Let's see, our next question here. We have about 2 more questions we can get in here. So what is the best way to find an estate planner, and which credentials and qualifications are important when selecting a planner?
It's a great question. If you're working with a financial advisor already, they have a network of estate planners, attorneys that they've worked with, and they get to know the ones that work well with their clients, and they get feedback from the clients. So that's a great resource. Is ask them, can you give me a name or two that you've had a good experience with, your clients have had a good experience with. If you're not working with a financial advisor, it might be, that's another good piece of this that they can bring a lot of value as well. So that's one real great source. The other one is, getting recommendations from your friends or family members who have gone through it. And then, then just talking to the person that you'll be working with. Again, I my biggest thing is, I've had clients that I've met with, and then for whatever reason, maybe the cost was more than they expected, and that's fine. And I just say, but just whoever you choose, make sure it's somebody, again, who specializes in this and isn't doing it on the side. And there's just a lot to know about this, the income tax issues and so forth, so that they'll capture all those. And then
as far as qualifications that you should be looking for too as well, I mean, obviously a JD.
Right. Well, they have to be a JD. They have to have their law degree. Years of experience. It doesn't mean someone with less experience is not going to do a great job. But like with anything else in life, experience is helpful. If you have a large estate and there are some particularly tricky issues, there is an organization called the American College of Trust and Estate Counsel. ACTEC is the acronym. And in order to be in that, there's about, I think, 2,500 around the country. It's an invitation-only group. You have to practice for 10 years or more, and then to be invited into it because of your professional reputation. Generally speaking, they do have experience. They're usually a little more expensive because they're recognized as being some of the best. But there's a directory that you can find on their website of Minnesota fellows, and that's a nice place to look as well.
Great. Okay. Well, our last question here. So if we reside abroad outside the United States, should we have an attorney in the United States create a will as an American citizen, or can it be done by an attorney anywhere and still be applicable globally? I don't know if that's kind of a big question here, but so I don't know if we have time.
Well, we can address on it real quick. If you have those issues, definitely you talk to your attorney. They can fill you in on that. Generally speaking, if you're an American citizen, you have property here, regardless of where you're living at the time, you want to have a will for your American property. Now, if you own property in another country as well, we'll often have a will for your United States property. It's kind of limited to that, and then work with an attorney in France or wherever that home may be to control your foreign property. Because, for instance, in France, they don't recognize trusts, or they have a different structure that's not like ours. So when we say trust, they don't recognize it the same way. So if you want to do something like that with a French property, we're not qualified. Nobody here really is qualified to do that. You would want to work with a French attorney. But so we usually will do a United States will and then encourage you to do a foreign one as well.
Great. All right. Well, that wraps up our Q&A section. And we appreciate you being able to be here with us today, and thank you for joining us. We've hopefully been able to demystify the process of estate planning for you, and hopefully I've also given you some helpful tips as you consider creating or updating your own estate plan. We have our contact information here, that if you would like to follow up with us afterwards, as far as by phone or by mail, please feel free to reach out to Ben or myself. And just want to say thank you again for being here with us today. Signing off from St. Thomas, this is Chris Fahey and
Ben Carpenter. Thank you very much.
Take care.